नमस्कार दोस्तों, आपका स्वागत है योगेश महाजन लीगल चैनल पर। योगेश महाजन लीगल चैनल पर हम आपको प्रस्तुत करेंगे नवीनतम सुप्रीम कोर्ट के फैसलों और विभिन्न अन्य न्यायालयों के फैसलों पर और विधि ज्ञान को प्रसारित करने का प्रयास करेंगे। इस चैनल पर हम न्यायिक फैसलों के महत्व को समझाने और विधि समझौतों की युक्तियों को समझाने का प्रयास करते हैं। हमारा मकसद है कानून और न्याय के क्षेत्र में ज्ञान को आपके पास पहुंचाना, तो कृपया हमारे चैनल को सब्सक्राइब करें, घंटी आइकन दबाएं, वीडियो को लाइक और शेयर करें।
Friend, this is a video based on a new judgment passed by the Honorable Supreme Court of India on 24th of January 2024. The Hindi version is already been uploaded, and this English version is made for the non-Hindi speakers. So this is a case of between the Central Bureau of Investigation versus the respondents, and where the Central Bureau of Investigation has filed a special leave petition challenging the order of the High Court, in which the Honorable High Court has dismissed their criminal miscellaneous petition, which was filed under Section 482 of CrPC, and upholding the order of the Session Court. Here, in this case, the respondents have been granted a default bail under Section 167(2) Subpart 2 of CrPC, and only on this ground that the investigation for the other accused has not been completed, so they are eligible for default bail under Section 167 Subpart 2 of CrPC. What the Honorable Supreme Court has held, let's come to the judgment and see the contents, and let's try to understand the interpretations made by this Honorable Supreme Court of India in this judgment. So the appellant in this judgment has challenged the High Court orders dated 35th of May 2023 in criminal miscellaneous petition number so and so, upholding the order passed by the special judge on 3rd December 2022, by which the respondent number 1 and 2 has been granted a bail under Section 167 to CrPC. So Section 167 Subpart 2 CrPC says if the investigating officers unable to complete the investigation within the stipulated period, it's usually a 90 days for the offenses which is more than 10 years and 60 days for the offense for the other offenses. For heinous crimes, the span period is 90 days. So the Session Court or the special judge has granted the bail to the respondents number 1 and 2, and aggravated from that order, the Central Bureau of Investigation has filed 482 CrPC again before the Honorable High Court. Honorable High Court 2 has dismissed their petition, and aggravated against that order, Central Bureau of Investigation files a special leave petition before this Honorable Supreme Court of India. Let's come to the facts. The facts was there that the present appeal are that an FIR number so and so came to be registered in CBI so and so New Delhi on 20th of the short facts giving rise to the present appeal are that the FIR number so and so came to be registered in CBI New Delhi on 20th of June 2022 on a basis of the complaint lodged by the DGM Union Bank of India's Mumbai for the offences punishable under 409, 420 and 477A of Indian Penal Code, read with Section 13 Subpart 2 of Section 13 Subpart 1 Subpart D of PC Act, that is the Prevention of Corruption Act, and against the One Finance Corporation Limited Company and 12 other accused persons. So in the FIR, it was alleged that this financing company, which is headed by one chairman and the managing director, along with the 12 other persons, has entered into a conspiracy to cheat a consortium of 17 banks led by the Union Bank of India, and principles of that conspiracy, they siphoned off, they misappropriated a significant portion of the funds by falsifying the books of account of so and so and deliberately dishonestly defaulted on the payment of the legitimate dues of this consortium bank. So the complaint was filed on the grounds that this company has made siphoned off some money. They have managed to take some loans which went into the 4,022 crores, which will cause us a loss of around 34,000 crores to the consortium of the lenders from the period of January 2010 to December 2019. Respondent number 1 and 2 were arrested by the CBI, and then the FIR, in the connection with the FIR, and then they were sent to the judicial remand. After carrying out the investigation, the charge sheet was filed by the authorities. This is section 120B, that is relates to the criminal conspiracy, and the relevant provisions which are the cheating, which relates to the cheating and forgery. Read this section, the provisions of the Prevention of Corruption Act against some 75 persons. Then respondent number 1 and 2 files a bail application under section 167 subpart 2 of CrPC on 29th of October 2022 before the special court, seeking the statutory bail. And since no final report was filed, they said that they've made there is 2 grounds before the session court. Number 1, that they applied for the statutory bails. That means that the investigation has not been completed. Second is the alternative seeking this, that in view of the lack of jurisdiction of this court, there was no approval under section 17A of the Prevention of Corruption Act, which was amended in year 2018. Now, how the special court voided its order dated 26th of November 2022 held that they have the jurisdiction in this matter, and by separate order on 26th of November 2023, the special courts took cognizance, means they took cognizance of the alleged offences against all the 75 accused on the basis of the and issued the protection warrant against the accused number 1 and 2, since they were in the custody, and issued summons and the warrants against the remaining accused. Then on special court on 3rd of December 2022 made their version, means they have passed an order on 3rd of December 2022 and held that since the investigation has not been completed, it's incomplete because the remaining charge sheet is pending against the other accused only. So it's found that charge sheet was just a piecemeal against and further held respondent number 1 and 2 were entitled for the statutory bails. So CBI, the special court granted bail to the respondent number 1 and 2, since other means they found, the special court has found that this was just a piecemeal and found that charge sheet was incomplete. The CBI then filed aggravate against that order, filed a petition and read with section 482 that relates to the inherent powers of the court, and section 439 subpart 2 of CrPC before this Honorable High Court. But the petition was dismissed by this Honorable High Court, and since the petition was dismissed, so order of the special court got upheld. And then before they then aggravate against that order, they filed a special leave petition before this Honorable Supreme Court of India. They made a submissions. The counsel for the appellant, that is the CBI, they made a submission before this Honorable Supreme Court of India. They says that that charge sheet was filed by the CBI on completion of investigation, cured 75 accused, including the 75 present respondents, and stating that further investigation some accused was pending. It does not mean that incomplete charge sheet was filed against the respondents. Their main contention is, since the charge sheet has already been filed, investigation against some of the respondents, some of the accused are pending. It doesn't mean the charge sheet is pending. This is self-explanatory. ASG submitted that report under the section 173 CrPC filed by CBI was complete as all details are required by the law. So it means, and according to when the charge sheet is not, so they made this ground in case if CBI did not file the charge sheet, then only then accused has got the right to seek the bail under section 167 to CrPC. Once the charge sheet is filed, merely some investigation is pending against some of the accused, it doesn't mean it does not gives the right to the respondents to apply the bail under Section 167 Subpart 2 of CrPC. So this was the main ground which they have raised, and they are relied upon certain judgments. And while the opposite party has opposed their contentions, now the court has made an analysis and they first consider the provisions of Section 167 CrPC. The 167 CrPC says procedure when investigation cannot be completed in 24 hours. So in that case, the magistrate grants time to the investigating agencies. That is, at one time they are used to grant they grant 15 days time to complete an investigation, which can be extended, but not more than a period of 90 days if the offense relates to some heinous crimes, murder, and some other, where the offenses are related to more than a period of 10 years. But in other cases, normally it's 60 days. So 60 days and 90 days are the time. And Section 173 relates to the report of the police officer on completion of the investigation. So this says that Subpart 2 says that officer in charge shall forward to the magistrate the cognizance to take the cognizance of the offence on the basis of the police report. It means the magistrate will have to take cognizance when the police files their final report under Section 173. That's called chargesheet. But the chargesheet must contains the name of the parties, the nature of the information, means under which provisions they have been booked, the name of the person who have been acquainted. It relates to the witnesses, whether offence appears to be committed, if so, by whom, whether accused have been arrested, means, and which is self-explanatory, and when he has been released on bail, whether he has been released on bail, if so, whether with or without sureties, and whether he has been forwarded under Section 170. These are the ingredients under Section 172 Subpart 2 of CrPC. So the now court held there cannot be disagreement where it's well settled legal principles. Right to default bail under Section 167 to CrPC is not a statutory right, but it's a right flow under Article 21 of the Constitution of India. It means the accused has got the statutory as well as the fundamental rights to be released on bail, which is well defined in the section Article 21 of the Constitution of India. Court further says indefeasible right, and it but can be enforceable prior to the filing of the challan. But in case the challan has been filed, then they loses this right to file an application under this provision of this act. Then the only remedy is that to contest the bail application, to file the bail application, and the court can grant him the bail on the basis on the merits of the case. Once the charge sheet has been filed, then the accused loses the right. So this is the outcome which the court has come. Then they relied upon certain judgments. Final version they have come with this. And the final version was that, in the view of the settled legal position, the court has held, we have no hesitation to hold charge sheet having filed against the respondent within the prescribed limit, and cognizance has already been taken. The court has held, since the cognizance has already been taken by the court, because the police has filed the charge sheet, and further held, since the respondent could not have claims the statutory right of the bail under Section 167(2) of on the ground investigation of the other accused was pending. So court has held that merely the accused cannot avail this right. Since investigation other accused is pending, means police has completed their investigation against the respondents accused. Merely on this grounds, other accused are pending. They can't take this benefit on this ground. So court further held that special court as well as the high court has committed serious errors of law in disregarding the legal position initiated and settled by the law. So they could allow this petition for issue further directions that respondent accused shall be taken into custody in case if they are released on default bail pursuant of the impugned order. Court has further clarified that this observation, this judgment shall not influence the special court, the high court, while deciding other proceedings, if any, pending before on merits. So the court has said that we have only expressed or made an observation on the provisions related to 167(2) CrPC as well as on Section 173 CrPC. So they are allowed, the appeals is accordingly allowed. So this was the case which were pronounced on, this was the judgment which was pronounced on January 24, 2024. January 24, 2024.
उम्मीद है कि यह वीडियो आपको पसंद आया होगा। अगर आपने अभी तक हमारे चैनल को सब्सक्राइब नहीं किया है तो कृपया इसे सब्सक्राइब कर ले और बेल आइकन दबाकर नोटिफिकेशन प्राप्त करें ताकि आप हमारे नए वीडियो से अपडेट रह सकें। अगर आपको यह वीडियो पसंद आया हो तो कृपया लाइक करें और अपने दोस्तों के साथ शेयर करें। हमारे चैनल पर आपको न्यायिक मुद्दों, कानूनी सलाह और कानूनी अपडेट्स के बारे में नवाचारिक और महत्वपूर्ण जानकारी मिलेगी। हमारे साथ बने रहें क्योंकि योगेश महाजन लीगल आपके कानूनी सवालों का सहायक है।